Hello everyone, do you hear me? So if someone could type just, yeah, thanks Victoria. So I assume we may start. My name is Ilya Gorychev, I'm practicing IP lawyer here in Russia. Thanks Tatiana also for noticing that the sound is okay. So my name is Ilya Gorychev, I'm a practicing IP lawyer, work at Gorodissky Partners as senior lawyer, specializing and focusing primarily on IP protection, litigation, with focus also on trademarks, domain name disputes, and other IP litigation aspects. Today we will speak on best practices for domain name disputes. Uh, so, first of all, I would like to cover some aspects of IP landscape in Russia within the context of domain names. As it's seen on this slide, Russia is quite a big state with a number of population. It's a growing market. It's a big market with developed industries, with developing e-commerce. The number of internet users in Russia is growing constantly. Russia has popular domain name zones, among which is .ru, .rf, which is the abbreviation for the Russian Federation, and the domain zone .su, which is the abbreviation for the Soviet Union. On this slide, I take the official statistical information from the Russian regulator, state internet regulator, which demonstrates that as of the last year, amount of domain names was growing. And not surprisingly, the more domain names are appearing, the more trademark conflicts, the more firm name conflicts, the more IP disputes may appear. So domain names in Russia are not recognized as a separate IP asset, unlike trademarks or firm names. The Russian Civil Code, which is the main authority in Russia for IP legislation, defines domain names as means of addressing in which trademarks or firm names may be used with consent of the trademark owner or with consent of the firm name holder. There is a legal definition of the domain name, which is given in the federal law on information protection. So domain name is defined as a symbolic identification, which is designated for the website addressing on the internet for the purposes of accessing the information posted on the internet. There were suggestions, there were some legislative initiatives to include domain name as in the list of IP assets, but those initiatives did not mature into law. So in Russia, what is important in considering litigation in Russia is that we have two main jurisdictional venues in which a domain dispute may potentially go. Namely, there is a system of courts of general jurisdiction, which normally hear disputes which are initiated against individuals, which do not hold the status of individual entrepreneur or individual businessman. Other types of disputes which have commercial element in it are adjudicated by commercial courts. Unfortunately, currently UDRP proceedings are not available for the domain name disputes in the .ru, .rf, and .su domain name zones. But UDRP principles are recognized by Russian courts, in particular by Russian commercial courts, and frequently the three main criteria in establishing unfair competition in the activities of domain name owner are used by Russian courts. There are two approaches in defining whether a domain name dispute go to a specific court, whether court of general jurisdiction or commercial court. The previously dominating approach was that a commercial court has jurisdiction over the domain name dispute in any cases, irrespective of whether the defendant has a status of individual entrepreneur or not. That was explained by the reason that domain name dispute, irrespective of whether the defendant has specific status, has relation to the commercial nature, because trademarks and firm names are assets primarily used in commerce. But starting, well, about 2 years, the last 2 years have seen an influx of another approach, namely the Russian Supreme Court, which is currently in Russia the main jurisdictional venue which hears supervision appeals against lower courts' decisions, issued a clarification according to which a dispute filed against an individual that does not have a status of individual entrepreneur, that dispute should be heard obligatory by a court of general jurisdiction. Those clarifications resulted in a series of procedural rulings by commercial courts dismissing claims against domain name administrators and containing instructions to file such type of cases to the Court of General Jurisdiction. In this regard, we would like to formulate a strategy tip which shall be considered, and that position is in line with the position of European Court of Human Rights, according to which, in case in a specific state, namely in Russia, there are two branches of judicial authority. In case one authority, well, commercial court, decides that it does not have jurisdiction over the specific case, then the other branch shall obligatory have jurisdiction on this specific case. That happens with domain name disputes currently. For instance, if you file a domain name dispute with the Court of General Jurisdiction, and Court of General Jurisdiction rules that it does not have jurisdiction because the dispute is commercial, because the dispute involves a trademark right, then you take that procedural ruling and safely go to the court of to the commercial court. And we see those examples in practice when the Court of General Jurisdiction refuses to hear the dispute because of lack of jurisdiction. The commercial court establishes its jurisdiction over the case. And the same happens vice versa. For instance, if commercial court decides that it does not have jurisdiction over the case, then the Court of General Jurisdiction establishes its jurisdiction over the domain name dispute. The main aspect which we consider before filing domain name dispute in Russia is how to correctly establish an evidence package. On this slide, you may see the mandatory evidence which is recognized by Russian courts. It is based on our professional experience. First of all is trademark certificate, trademark registration certificate, which shall be duly notarized and, as the case might be, apostilled, in case we speak on the firm name protection, for instance. Certificate of incorporation that I said, because in Russia, by virtue of Article 8 of the Paris Convention for Protection of Intellectual Property, foreign firm names, foreign names of foreign companies are recognized, and rights to those names may be enforced by filing the relevant lawsuit. In Russia, exclusive licensees may have a standing before court in enforcing trademark rights In this regard, if the case is initiated by the exclusive licensee, which acts as the plaintiff, there shall be relevant evidence in this regard, namely the copy of the exclusive license agreement, which in Russia is subject to state registration before the Russian Patent Office. Another main evidence is that domain names are used in many different ways, as the case might be. For instance, domain name may be simply registered and there will be no website at the address of the domain name. Another case when at the address of the infringing domain name there is, well, for instance, an online shop offering copycats or fake products or gray import products or whatsoever. In this regard, despite that Russian judges started accepting simple printouts from the website, still it is advisable to engage a public notary to obtain a notarized report of website inspection. A notarized report of website inspection is normally used by a Russian judge as a reliable evidence proving the way the infringing domain name is used. Another important aspect is that previously cease and desist letters in Russia were not considered as a necessary element to initiate court proceedings. However, starting from June this year, starting from June 2016, it is now obligatory to file a cease and desist letter against the domain name owner and wait for 30 business days since the dispatch of that letter. Otherwise, if you file a case in Russia against the domain name owner without complying with the mandatory cease and desist procedure, then the case will be returned and you will need to file that letter and wait for 30 days and provide that evidence to court. The case might be that novelty in the Russian legislation may be considered as aimed at decreasing amount of domain name disputes, allowing the parties to reach an amicable settlement agreement. From my practice, I see that many domain name disputes in Russia may be ended peacefully before the litigation is initiated, just by sending a cease and desist letter with strong legal argumentation. And in many cases, potential defendants surrender domain name, enter into negotiations. What is maybe quite practical is that maybe some of you perfectly know that there is a difficulty sometimes to establish who is the actual owner of the domain name because of personal data issues. For instance, if you take a specific domain name, type it in who is registered and see that the name of the owner is disclosed by referring to a private person. That is purely a personal data issue because according to the Russia data protection law and according to the rules established in this regard by domain name registrators, information on full name of the private person is not normally disclosed unless that private person specifically allows to do so. However, there is an option how to obtain that information. Such option includes filing an attorney request to the domain name owner, filing an attorney request to the domain name registrator. So that companies, there are dozens of them in Russia. The most, well, big of them, the biggest of them is the Rus Center. And Rus Center and other big domain name registrators normally provide information on the domain name owner, his full name, his or her full name, their full address, as per that attorney request. There is a possibility to obtain that information on the fast basis. It takes about 5 days. Regarding the optional evidence is the public poll opinions for complex cases when similarity between the trademark and the domain name at issue is not quite evident. Another interesting aspect is when you enforce a firm name right in Russia, it is always advisable to provide evidence that the firm name of a foreign company in Russia is known by Russian consumers. That may be achieved by providing printouts from mass media publications, advertising materials, statistical data, information from research agencies, and so on. So any documents showing reputation of the firm name in Russia. Regarding pre-trial options and steps, which every domain name dispute normally undergoes, is evidence gathering, which we discussed previously, cease and desist letter, which is mandatory for commercial proceedings, and responding to the question of Tatiana, for general jurisdiction courts, there is currently no such obligatory procedure as to file a cease and desist letter before initiating proceedings in court of general jurisdiction. However, sending cease and desist letter is also advisable. First of all, because it gives opportunity to end the dispute amicably. Second, because the fact that the defendant was put in notice of his or her infringement, then in case of no favorable response, judge will consider non-response to the cease and desist letter as bad faith by the defendant, and that fact may influence significantly the amount of compensation awarded to the plaintiff. And regarding to the question of Kirill, regarding the ways of how things, regarding how the cease and desist letter normally sent, if we speak about commercial procedure, it's recommended to send that letter by registered mail, because it's called Почта России, a Russian post office. So you send a cease and desist letter using the services of the Russian Post, which issues documentary evidence that the letter was sent. Regarding general jurisdiction court, if you file a cease and desist letter, it's always recommended to have evidence that you send that letter by the Russian Post. Anyway, the fact of sending the letter by the Russian Post does not exclude possibility to send that letter by, well, courier like DHL. You may also send by email, but those types of notification, they are optional, while sending by the Russian Post is what is recommended. What is recommended because it is reliable evidence that the specific letter was sent. In some cases, you may consider anonymous purchase of the domain name. Of course, it's understandable that in case we speak about defendants who normally proceed with registering domain names in order to, well, gain some commercial profit, for them, in case they're contacted by the trademark owner himself, then such guys may consider offering quite big sum of money. That is why, in case the domain name is not actively used and it is evident that the potential defendant registered the specific domain name without any bad reasons, maybe just with ignorance of trademark rights or due to some reasons, you may consider retaining private detective which may contact anonymous purchase under the bogus name, offering reasonable sum of money which is not high in order to purchase the domain name. A good option before initiating court proceedings is possibility to use out-of-court restrictions on using the domain name. That option is quite helpful in a situation when you want to avoid sudden transfer of the domain name by the defendant during court proceedings, in particular in a situation when no preliminary injunction was yet granted. That said, on the website of the Russian Coordination Center, which is in Russia the watchdog for the .ru and .rf domain names, it is possible to fill in the form indicating your trademark rights, providing evidence of trademark rights, indicating that the specific domain name infringes your trademark rights, and then the coordination center liaizes with the domain name registrator, and domain name is temporarily blocked. So it will be not possible within the specific amount of days for the administrator to transfer the domain name to the third party. In order for that term not to be dropped, you should provide evidence of the subsequent court initiation of legal proceedings over the specific domain name. And of course, one of the final pre-trial options, when it is evident that, well, there will be litigation proceedings, is to use preliminary injunction. Preliminary injunction allows to file a motion to court before filing the main action, which is aimed at blocking the transfer of the domain name. Preliminary injunctions are normally issued by Russian commercial courts, in particular due to clarifications by the Russian Intellectual Rights Court, which quite strictly explained to lower courts that preliminary injunctions shall be used in domain name disputes. There were, of course, examples of preliminary injunctions in domain name disputes before those clarifications by the Russian Intellectual Rights Courts, but after those clarifications, preliminary injunctions in commercial courts became, well, routine issue. In courts of general jurisdictions, I may not say that preliminary injunctions are quite rare, are quite frequent, but still it is possible to claim preliminary injunction, and, as the case might be, to persuade judge of the necessity to block transfer of the domain name before adjudication of the case on the merits. What about the remedies which we may seek in Russian court for the domain name? Of course, it's adjunctive relief, which may be preliminary, which we outlined, and permanent injunction, which precludes the trademark owner which precludes the domain name owner of using the specific trademark in the future. There are examples when you may claim domain name revocation or domain name termination. There are examples when you may claim domain name transfer, but regarding those two remedies, revocation and transfer, it's worth noticing that such type of remedies, they're already prescribed in the Russian rules on domain name litigation disputes, which are approved by the Russian Coordination Center. Therefore, it's recommended to use injunctive relief, claiming permanent injunction. Later on, when you obtain the effective court decision, you may go to the Russian domain name register, for instance, root center, and using the specific option, you may either seek domain name revocation or domain name transfer, because in Russia, the trademark owner, after successful infringement proceedings, has a priority right to register the domain name at issue. Of course, monetary reliefs are available for trademark infringement. There are damages possible, or instead of damages, monetary compensation, or how we call it, statutory compensation, which is procedurally of two types. Fixed type, so compensation ranging from 10,000 Russian rubles up to 5 million Russian rubles, or another type of compensation, twice the price of the license, which is normally granted for that specific trademark. Another option in cases where use of the domain name is accompanied by offer for sale of counterfeit products, and if in case of the successful infringement proceedings, judge issues a decision there are grounds to see that there will be decision establishing trademark infringement both in the form of domain name infringement and both in the way of offering for sale and sale of counterfeit goods. You may claim twice the price of the counterfeit goods at issue. If we speak about what happens normally, is that in the overwhelming majority of Russian domain disputes, the plaintiffs seek for this fixed statutory compensation, namely compensation ranging from Russian rubles 10,000 up to Russian rubles 5 million. It is the obligation of the trademark owner to indicate the specific sum of compensation he claims by reasoning it with evidence. For instance, evidence of bad faith, evidence of the infringement being negligent and things like that. But it is a judge discretion to decrease the amount of compensation using the criteria of justice, of reason, and so on. And one of the final remedies is publication of court order or publication of court decision in the special mass media in which the defendant openly rejected the owner's trademark rights. That remedy is not quite frequently used in domain name disputes, probably because any court decision is published itself in Russia in the Russian databases for court decision, which exist both for commercial courts and for courts of general jurisdiction. However, for complex cases which involve not only domain name claims, but more complex cases when the defendant disagreed with the trademark right of the plaintiff and published some articles which has bad PR effect, you may claim that publication of court order in that specialized media in which the defendant previously published something which denied trademark right of the plaintiff. Here we speak about some notable cases which influenced Russian judicial practice on domain name disputes. And first in our series of case studies will be the case Volkswagen.ru, when the defendant registered the domain name VW, which reproduced the well-known trademark Volkswagen. In that case, in the rulings on those cases, judges indicated that domain names have commercial value. Judges indicated that choice, registration, and offering for sale of the infringing domain name is an act of unfair competition. Judges also noted specifically that use of the infringing domain name tarnishes the business reputation of the plaintiff, of the IP owner. Judges also discussed the issue of abuse of right by the defendant. And that case is notable for analyzing the situation of passive holding of the domain name, when the defendant just registers the domain name without, without putting any information on the web page and the address of the domain name. As a result of this case, the trademark rights of Volkswagen were protected. Another interesting case is Swatch.ru, which involved trademark infringement of also quite well-known trademark rights used for watches. Judges also indicated that domain names have the identification function, the same function as, in fact, trademarks of firm names have. That case also involved passive holding, and judges indicated that passive holding is also an infringement because it attracts customers and it leads to unfair competition because the plaintiff in this case could not register the domain name which reproduces his own trademark. That case also involved invocation by the defendant of the limitation term. The point is that in Russia there is a limitation term of 3 years. So, for instance, if there is an infringement happening and you are inactive for 3 years, there is a chance that upon expiration of 3 years, you may be refused protection. That's called limitation term. In that case, the defendant tried to argue the limitation term, but judges disagreed with that aspect, citing that the infringement is lasting, so infringement continues up to the date of filing the lawsuit. Therefore, limitation term is not applied in this case. Currently, the issue of limitation term in domain name disputes is still, well, not unanimous. That is why it is recommended to act timely. When you find an infringement, it's better not to wait for 3 years or 5 or 10 years and then file a case. So that case shall be dealt immediately by sending cease and desist letters and by initiating court proceedings in case there is no favorable response to the cease and desist letter. In that case, Swatch.ru court also granted, in addition to the permanent injunction, court also granted transfer of the domain name from the defendant to the plaintiff. One of my favorite cases in Russian judicial practice is Mam.ru. That case was adjudicated by the Russian Supreme Commercial Court. The peculiarity of that case is that in this case, court used the Paris Convention for the protection of industrial property by qualifying the activities of the defendant, which was at that case an individual. Court qualified registration of the domain name and subsequent use as unfair competition. That's a kind of peculiarity because normally in Russia competition is used in commercial disputes which do not involve simple individuals. So competition is still a notion which requires some commercial aspects, some competing markets and so on. And clarifications given by the Russian Supreme Commercial Court in the Mam.ru case provided solid ground in subsequent cases to use provisions on unfair competition prohibition against individuals who do not have the status of individual entrepreneur. In this case, Mam.ru, the Russian Supreme Commercial Court paid specific attention to the use of UDRP criteria for qualifying the domain name infringement. The Russian Supreme Commercial Court specifically indicated the necessity of using those 3 criteria in establishing that the defendant has no legitimate interest in using the domain name, in citing that the domain name did not reproduce the trademark or firm name or surname of the defendant at issue. As a result of that case, the trademark rights of the mom of the plaintiff, which was the producer of champagne, were protected. That case, Mam.ru, is among the most cited cases in the Russian commercial domain name practice and is known among Russian IP professionals on the quite good scale. Finally, among the interested cases in Russian domain name practice is Nike.ru, case initiated by the well-known global producer of fast-moving consumer goods and clothes. In that case, the defendant owned more than 100 domain names which were offered for sale on the internet, and court noted that. Court specifically paid attention to the fact that registration of the domain name itself creates a threat of infringement for trademark rights. In that case also involved the use of the firm name, because Nike is not only a trademark but also a name of the company. In that specific case, the defendant argued that he was not intended to use the domain name for commercial activity, but simply for describing the information on the ancient Greek goddess called Nike. But court dismissed that arguments in indicating that, in fact, the defendant had no legitimate interest in using the domain name at issue, nike.ru. And the final issue which we speak today about the domain names in Russia is, of course, new generic top-level domain names. Russia, during the last years, has seen an influx of new generic top-level domain names appearing, numerous domain names, both of geographical nature, of commercial nature, and so on. For them, the Russian registrator established the proceedings to ensure its timely registration by trademark holders, like sunrise procedure. There were also land rush period when you might register the domain name on a priority basis, but for higher price, and general availability procedures when generic top-level domain name may be registered by anyone. What we may recommend regarding the infringements which deal with generic top-level domain names is, of course, filing cease and desist letters and use of UDRP and URS proceedings, which quite helpful in this regard, because still, when I previously started that unfortunately those proceedings are not available in Russia, the principle is that in Russia, judicial proceedings take several months. So approximately from 3, 4, 5 months in the court of first instance in the commercial court, while for the well-known international proceedings, the dispute takes not more than 2 months. So that's all that I would like to cover. So in case you have any questions, so please. Well, I see a question, can UDRP proceedings be expected in the coming years for .ru? Well, difficult question. Some discussions are going on in this regard. We hope so. We hope so. I guess I responded to previous 2 questions by Tatiana and Kirill. So any other questions? By the way, in case those who attended today's webinar, in case you have additional questions, you may just email me, or I will type my email. Thanks, Catherine. So thank you very much for listening, for those who listened to that presentation. Yeah, thanks Edouard, thanks Sebastian, thanks Tatiana. So I hope that your trademark rights will not be infringed. Thanks, bye, take care, and have good day or evening depending on your time. Thanks, bye.